Hello, everyone. Can you hear me? It's nice to see you all shuffling into the room. Feel free to let me know in the chat if you can hear me. I'll put the chat up here so that I can keep an eye on it as we go. Can you hear me? Am I live or am I talking to myself? Which is always a little bit of a scary thought. Yes, Nicola, thank you so much. Mark, excellent, it's working. Very happy to hear that. Well, we're up to 10 people. We've got quite a few more registered. Maybe people are running late. So welcome. Where are you guys coming from today? Is it morning? Is it afternoon? Friends in WA are in the morning, I think, still. Just turned midday here in Adelaide. And all our Eastern Seaboard's friends are checking in during their lunch break, which is great to see. It's lovely to see you all coming in. All right, well, since we're 1 minute past 12 now, I'll get started. Welcome to today's webinar, a hot topic around our office. What agreements do you really need a lawyer to prepare for your medical practice? This is a topic that came up in a recent strategy day we had. It's something that our team thought that you guys would be really keen to know. So let's get started. As you know, I do always start, let me get to the next slide, start with a disclaimer. Because this presentation is for general guidance only, legal advice should be taken in relation to specific actions and specific issues. So what I think that you might want to know is you might be thinking about which legal agreements are critical to your practice operations, but before you invest in one, what do you really need to know? Well, the learning outcomes today hopefully will help with what you really need to know. What I think you'll be interested in are the greatest areas of risk in your business. What agreements are the deal breakers that you absolutely need a lawyer to check and shouldn't be trying to draft yourself? And which agreements can you get away with downloading from the internet? So for those of you I haven't met, my name's Sarah Bartholomeusz. I'm the founder and principal of ULegal. We're a law firm that helps doctors and practice managers and allied health practitioners get protected in their practice. So my big passion is to make sure that practices are protected by having the right legal framework in place to be able to run their practice and focus. Oh, sounds coming and going, Nicola. Maybe I'll take my mic out and I'll just rely on my laptop sound. Thanks, Nicola. So my team are really passionate about protecting practices, and one of the main reasons for that is I used to work as a litigator, trying to bring people down essentially, but now I want to try and make sure that they're as protected as possible rather than having disputes that can cost so much financially but also so much emotionally. So let's get started. That's who I am and why I'm in it. As you can see, there's me reading a copy of my book. I've written a book called Growing a Medical Practice from Frustration to a High Performance Business. We've just released the second edition. It's here on my shelf. Here it is. Because the pandemic really threw up a whole lot of other issues for medical practices, as you can imagine, to think about from a legal perspective. All right, let's get started. Hopefully that sounds better now, Nicola. Shout out if there are any other issues. Okay, critical issues. The first and main one is, where are the greatest areas of risk in your practice? It's something that I guess a lot of practices kind of think about a lot because Managing clinical risk is such an important thing that you do every day as part of your job. But where are the other areas of risk? And really, that comes down to your practice. It really does depend on how you run your practice. And having been working exclusively with doctors for 3 or 4 years now, there is big variations about how people run their practices. And the different nuances that they have, depending on if they have specializations or if they have areas of particular focus in their practice. So let me just do a quick explanation of what risk is. It's quite simply exposure to danger, harm, or loss. And this doesn't strictly mean loss of income, profit, or property. Before, when I mentioned litigation doesn't just cost money, it does cost your sanity. And I know that because even though I have experience as a litigation lawyer, my husband had a dispute with a business partner, and the arguments in our house about finding documents for just the discovery or disclosure process and the high emotion that was running for the whole period of that dispute, that there are other things that can be damage to your reputation, the goodwill of your practice, and importantly, risk management, which we'll talk a little bit more about now as well, isn't just about avoiding risk. Because if you run a business or a practice, you know that you can't make the most of it without accepting that there is some risk. So you might identify that there are some risks that you want to avoid at all costs, but people don't grow successful businesses by avoiding all risk. Instead, what we need to do when we are thinking about what agreements should be checked by a lawyer and which ones we can sign off ourselves is how to identify the risks, profile the potential consequences, and make calculated choices when we're going to do that as well. And that can be done in accordance with or in consultation with an accountant, for example, or another professional advisor. Many of our clients work with business coaches that work specifically with medical practices, and they are incredibly helpful in this area, particularly if they have worked as doctors before. So your risk appetite is really diverse as the people on this webinar, which doesn't make this a super easy webinar topic, I've found. But what I'll go through is some potential risks that might affect you. And where this came from is actually the book that I held up earlier. I went through these risks in 2018 when I was writing the book, and funnily enough, the third one down you'll see is pandemic. But running a business really does create different types of risks and reward. And unlike patient and doctor risk, which you as practice owners and practice managers do deeply understand, there can be many different types of business risks that you might not have even thought too much about. Risks can be internal and external to a practice. They can be direct or indirect in relation to the practice's ability to operate. Risks can be hazard-based, for example, a chemical spill, or uncertainty-based, like a natural disaster, or associated with opportunities even, taking them up or ignoring them. Given we're a week away from the end of financial year, I've been hearing from quite a few different doctors this week about opportunities to either buy into a practice or buy out their practice, fellow practice owners, or sell out and move to a different practice. It's really been a week for those conversations, and that's a risk. If you're in a practice that you know and you understand, is very different to the opportunity of taking up a new practice opportunity without really understanding what it's like to work there until you actually get there. So these are risks and opportunities as well. The type of risk that any practice faces will be specific to your practice and also your practice's goals. One practice we've been working with quite closely is a GP practice that specialises in skin. And so they've been working on their online shop, and they've been working on how to market to people to come in and hopefully buy products as well as seeing their doctors. So it's a bit of a different take. And so it's not just a vanilla GP practice, and that suits their goals and where they're going as well. So just like you do with patients, to effectively manage patient risk, you should think about and prepare for internal and external scenarios that may affect your business. And this was a list of ones that I came up with when I was planning my book. So, or writing my book, I should say. So natural disasters can include floods, storms, bushfires, or drought, a pandemic like the one we're going through, legal issues like insurance issues, resolving disputes, contractual breaches, non-compliance with regulations and liabilities, letters from regulators that you didn't expect to receive, was a conversation I had with someone earlier today, and how to best manage that. Global events like pandemics and interruptions to air traffic, technology like computer network failures, and problems associated with outdated equipment, regulatory and government policy changes like water restrictions, the quarantine restrictions we're seeing now, carbon emission restrictions, and tax and environmental issues can affect your practice as well. Work health and safety, like accidents caused by materials, equipment, or the location of your practice. We've got, I'm the chair of a not-for-profit, and in our current location, we have somebody who doesn't have a home, who's been living in the doorway of our not-for-profit, and there's potential workplace health and safety risks with them if they come and wake him up and he's not in a good mood. So we've got really to think about a lot of things as business owners, property and equipment, like damage that can occur from burst water pipes or robbery or vandalism, security, theft, fraud, cash flow shortages, staffing issues, management and difficulty filling vacancies with the lack of people coming into the country. There's lots of different industries that are experiencing current difficulty recruiting. I know that GPs have often had problems recruiting the right fit for their businesses. So that just seems to be an increasing issue for a lot of people. Supplier issues which have occurred because of the pandemic as well, like interruptions to the supply chain, have affected a lot of different people. Changes in the market even, so consumer preferences and increased competition, failures or interruption in relation to the delivery of your power, water, transport, or telecommunications, which I've had issues with practices before who haven't been able to have a call because there's been a Telstra outage in their area, which you think you can just rely on. So they're all potential risks. Indirect risks include supplier-related risks. We've seen those with the vaccines. Could be other supplier issues with the supply chain difficulties out of China. Patients can be personally affected. We've seen that through the pandemic. They've changed their priorities. People may be not as willing to come into the practice and would prefer telehealth, which of course is then linked with government changes that we can't control as well, or general location effects. So, for example, if you're in the CBD of Sydney right now, you might have issues if there's a snap lockdown that's called by the Premier because of the health crisis that we're all going through at the moment. It does make things difficult to plan. But there's different strategies in risk management. And so in talking about which agreements you can use from the internet or use from a template versus having a lawyer draft, I wanted to talk about the different strategies in risk management, because it's not a one size approach, you should think about what's going to work for your practice. So you can either try and avoid risk completely, which I did mention you could do by not entering into agreements or arrangements or taking up opportunities. You can mitigate risk in certain ways. You can transfer risk, which we do with our insurance. When we have professional indemnity insurance, we're transferring the risk of us making a mistake or doing something wrong to that insurer by the extraordinary amount that we pay them each year. Or we can accept risk. And in understanding the position, it does make it a lot easier to accept risks. You know what can go wrong, what can't go wrong, what might go wrong, what might not go wrong. An example of that might be a practice that has never had agreements with its independent contractors and just worked on a handshake. And that's fine while you're willing to accept the risk of what might go wrong in that scenario. But if you're not, then maybe having a written agreement can help transfer and mitigate and avoid some of the risks that you might not even know that you don't know. So managing potential risks, this is the way we do use those. Insurance does transfer risk, as I just mentioned, and agreements which are in writing help avoid risk and transfer risk. For example, I recently had a conversation with a doctor who wanted to make sure that they had transferred the risk to a contractor in the event that there was a shared debt recovery by the government. They didn't want to have to be paying on behalf of the practitioner, so we've worked into their agreement that there's an indemnity that if they do have to pay out, that the practitioner has to pay them back. A regular review process of your risks can help avoid, mitigate, transfer and accept risks, because you know what your risks are for your particular practice and you've got strategies in place in relation to them all. Continuing education, attending those business for doctors sessions on a regular basis can help mitigate risks as well, because you are more aware of them. So maybe that also helps you accept risk. And then having backup suppliers. So we've got a tech client, a health tech client. They build certain devices, and they up until earlier this year only had one supplier out of China, which was a huge supply risk. And they said, oh, we can't get another one. Our contract says we have to have only one, but they managed to negotiate to get another one in a different country. So making sure that there's backups if there is an issue with supply. Recent risk review for a medical practice client. I thought this might be really interesting for you because it's a real life one that we've recently worked on. And these are the issues that they came up with Daniela from our team and their team as well. So they thought the biggest risk, or one of the biggest risks, was the failure to retain staff with the requisite skills and values. The failure to meet health and safety obligations owed to employees and patients in the event of an emergency. Key person dependency. This practice was owned by one particular doctor, and they really were working so much that their team thought, we need to be really treating this doctor like the key person that they are, and they need to have a health and well-being plan to make sure that they don't burn out and that they're always giving their best to the business, because without them it would be a critical issue. Failure to protect patient data and system availability, so really relying on their CRM and worrying that there might be some sort of data breach risk as well. And failing to maximise practitioner and room capacity, really making the most of the assets that they have and streamlining things so that practitioners were really working all the time they needed to be working and not wasting time doing things that other people could potentially be supporting them with. Failure to meet legal and compliance obligations was a really big one for them. So really having that awareness and regularly running a process like this was to help them, and failure to have appropriate systems for the particular business and its growth. So critical issues. This is what you're here for. What agreements are the deal breakers that you absolutely need a lawyer to check and can get away with downloading from the internet? All right, I've held you in suspense. The biggest risk for most businesses that I see having issues is staff. You really can't grow without them, but you do need to take care of them. You want them to be doing the right thing by you, and you want to be doing the right thing by them, or you wouldn't be growing a business. So tight, well-drafted employment agreements are an absolute no-brainer for a practice to be able to protect themselves. And that's not just employment agreements. I'll go into that here. So your staff are a risk, as was identified in a couple of those different points from the review that we did for a practice recently. So as an employer, you are vicariously liable for the acts and omissions of your staff, but probably not vicariously liable for the acts of your contractors. They tend to be more responsible for themselves. Staff can do all sorts of things like damage your reputation in the community by telling people things that maybe you don't want, or starting a practice close by, which we see doctors do from time to time. And staff can damage your reputation in the community, which you want to try and avoid at all costs. And that's a risk that can be mitigated by having great open communication with your team. We recently had a matter come to us where there had been a staff member who'd left, and a current staff member had given them a new password so they could actually get into the CRM system on the weekend. And we knew that they did that because they left their name on notes that they provided. But what was troubling to the practice owner was that they couldn't get the person who had given the team member, ex-team member, the password to tell them which staff member it was. They just didn't know. They asked them all together, they asked them one-on-one, and they couldn't work it out. And that's a really big trust issue for a practice owner, because they want to know that if there's any issues that come up, they want to know about them early. They don't want people hiding the truth from them. They want to create that culture of openness. So how to mitigate? I'm already talking about that, creating that culture, written agreements with employees, and also services agreements. And services agreements are one that you do really need to work with a lawyer on, or have had a lawyer drafted, because the risks of not having agreements with doctors that are not properly drafted or improperly drafted or don't cover everything you need to can be huge, including the risk of payroll tax being applied if their contractors are deemed to be employees. Not something you want, but something that can be avoided with an investment in a properly drafted agreement, which you can then use for all of your contractor staff members. And often rolling that out is more of an issue that is a marketing issue, probably, because a lot of doctors don't like signing agreements, but it's to protect both parties in this case. Policies and procedures, you don't need a lawyer to draft those, but you do need them. They mitigate risks associated with employees, and a delegation of authority policy can also help to create clarity on the responsibility of certain team members, so that you know what people are supposed to be doing and what areas of power they have. Can they go out and buy stationery without your permission? Can they enter into agreements for financing without your permission? So making sure that those boundaries are clear. So how can an employer protect themselves? Proper agreements with staff, avoid and transfer are what that does. Policies and procedures also avoid and transfer, and disclaimers and consent forms transfer risk from you to your patients, and insurance is a transfer as well. So disclaimers and consent forms, I've seen lots of different consent forms through the years, and it's probably worth investing in having a lawyer check or draft those rather than just relying from ones on the internet, because there's so much value that you can get from transferring that risk. Another big risk for most businesses is the relationship between owners. It really is like a marriage, going into business with someone. And if you've got an owner's agreement, and I say that because practices have different setups, so it could be a shareholders agreement, a partnership agreement, a unit holders agreement, or an equity holders agreement, just depending on the structure. They avoid disputes because they set out processes on how disputes should be and can be resolved, and how people can get in and out of the partnership by setting out a process, which makes things a lot less emotional in the event of something going wrong, or just a change in circumstances. A practice owner who I've been talking to over the last few days just thinks that their current practice owners, maybe they're not a match for them for values and growth-wise. They really want to make a big difference in the world, and their fellow practice owners are happy running their family practice that they've run for many years. And there's no right and wrong in this. It's just making sure that there is a way for people to extricate themselves without it being a very big deal. Hidden risk for many practices is the growing online presence of practices. So most practices now have a website and maybe haven't got proper terms and conditions for how those how their practice operates, and privacy policy as well. So I've been in touch over the last week with a practice that has just signed up with a new third-party owner to hold their data. So they used to hold it in-house themselves. It's now gone to a cloud provider. So they needed a new privacy policy. But so starting new things can be a great way to jog your memory about these documents. Or if you sign up to work with HotDoc or HealthSite or one of those online sites that your patients put information through a third party, it doesn't directly come to you. Making sure that those documents are up to date can help protect you, and making sure that you check that the other provider has a privacy policy that looks like it's going to protect your patient's data. So, important question, can I use templates offered by my professional associations like the AMA or AAPM? And again, there's no straight out answer to this. I think it just depends. It depends on the template, and it depends on the way you run your practice. So, for example, those website terms and conditions, they look very different for the practice I talked about earlier that has started selling a lot of online products to a general practice that normally doesn't sell products at all. And whether or not all of these different permutations of business have been taken into account by the different professional associations, I'm not sure. They probably have a great disclaimer on them. And so just be careful using them is probably my advice. They do tend to be drafted for the lowest common denominator, which isn't a bad thing. If you run your practice very traditionally, then they likely will cover you. But if your practice is doing something slightly different from the norm, it may not suit your needs, and you may need something more bespoke and to have a lawyer brain on it for a few hours to make sure that it's properly protecting you. So downloading agreements from the internet or copying your peers is a high-risk activity. Why? Well, in the same way that using templates can be right and cannot be right, it may not be right in your particular circumstances. And also, you may be breaching another person's copyright by just copying and pasting and just adding your own details into them. So just be very careful about doing that. I'm not telling you not to do it. As I've said as part of this presentation the whole time, you need to take risks to be in practice. You are taking a risk as an owner. So it's just something to be aware of that you might not have been aware of before. Another critical issue that I've been coming across lately is who should I be listening to? So I've been getting some panicked calls from people because they've read an article that might have shattered their worldview, and this is a critical issue. There are blogs that do make their way into our community that are designed to scare you into action from some service providers, and some of those people are even giving advice outside their area of expertise. But if you do read an article that shatters your worldview, we've got a very open community of experts and practice managers and doctors, I think, in our Facebook group, You Legal for Doctors, but also in other groups. There's wonderful conversations that are facilitated every day that connect us. And so if you do read an article, talk to someone. Don't lose sleep over it, please. If you're worried legally, you can talk to a lawyer, you can talk to your insurance broker or insurer direct. Insurers are excellent in terms of the advice that they'll provide when you're feeling panicky. Make sure that you think through things critically. Don't just panic, be objective, and rely on our ecosystem to ask. If you're worried, tag me. I'm happy to weigh into conversations anytime for people who are worried about things. And if it's something that I think we should have a one-on-one conversation with, I might send you my booking link and we can have a chat for 15 minutes at no charge to you. So hopefully that offer is valuable to you. I want to tell you about one of our clients, Dr. Jamie Lee. She was an entrepreneurial doctor managing her family, growing family, and also the main breadwinner in her family as well. She was very passionate about a business idea that she had called Virtue Packs, but she was very worried about the compliance obligations and what starting a practice might mean for her, and it was really weighing her down. She couldn't get her head around it all, and she wasn't sure who to turn to for help. So she found us through a mutual connection, and working together with Jamie Lee, we were able to help her overcome her concerns and the overwhelm that she felt in starting the practice, and help her with her compliance obligations as well. So now she's passionately running her business free from those concerns and really focused on helping get primary care workers and childcare workers vaccinated so that they are protected and the kids are protected as well. So my final point for this session is really to leverage an expert when you need to. And I think I did that in the last slide about not panicking and being objective if you read something that shatters your worldview. There's so much value. There are so many experts out there, and using an expert that you trust can bring you new ideas, best practice, and also accountability. You've already got new ideas in your head from coming today to know what you can get from leveraging an expert when the time is right. This is the facilitated risk review that we did with the client that I mentioned earlier, where I listed their top 7 risks that their team came up with. We do a facilitated risk review, which we facilitate with a Zoom session with your team, and live on the call we come up with the risks, and we come up with a list of those risks and what you can do as a team to help manage those. We do some pre-work with you and your team to come up with them, and then we'll prepare a risk register for each risk, and then follow up with you to make sure that you're confident to take the next steps. And for some practices, this is a great sleep at night investment. So I just thought I'd mention it on this call. If you're interested in this or talking to me about anything else, This is my booking link. You are welcome to book in with me. I should put that in the chat. Oh, no, I can't put it in the chat. I'll put it in the webinar resources that we send out with after the call, after the webinar, so that you can book a call with me if you need to. You are very welcome to reach out. You've all got my email address anyway, so I can send that to you if you're keen to book in straight away. Now, do we have any questions? I feel like I've been talking and talking. My voice is hoarse. Anything, or what's been valuable about coming today? Your number one takeaway, maybe, if there's no questions. Love to hear from you guys. Here we go. Mark says, in a service agreement is a clause allowing the practice to inquire upon the practitioner's NDO reasonable. So Mark, what we usually would do is we would require the certificate of insurance to be provided to the practice annually. I have contractors that work in my practice, and we do that. Each year we get a copy of their practicing certificate and their insurance as well. So it's definitely reasonable. You probably shouldn't go directly to the MDO, but you can ask the practitioner to provide that. And I do that as part of my practice as well, as part of my own risk management process. So that's a great question. Anyone else? I love questions about services agreements. So what can be scary, I think, is the risk of the risks that you don't know. So I've talked to 2 doctors this week who signed up with pathology people when they first got their lease, and they didn't follow the Red Book procedure because they didn't even know about the Red Book procedure, and now they've got letters from the Department of Health asking questions about the arrangement. So I think that's where a risk review can absolutely be worth the investment, to avoid the stress of hearing from regulators like that. All right, Mark, your question. Next question. What does the phrase as is means? For example, the practice provides services as is. I'm not really sure. In that particular instance, maybe it means that they provide the services that they provide, rather than providing bespoke services that you might request or a doctor might request. But I haven't seen that in a template or an agreement, I don't think. But that's my best answer with the information I've got so far. You're welcome, Mark. Oh, we've got another question. Liesl, how long do we need to keep service agreements and or employment contracts once the provider or employee in question has moved on? The answer to that is 7 years, Liesl. That's your obligation for keeping those, and then you can work out a way to purge them depending on how you keep them. Keeping electronic copies is now acceptable as long as you can keep them safely, and you know that some IT disaster isn't going to make them disappear. But yes, 7 years is the answer. And Liesl, in my book, there's actually a useful summary of how long you need to keep specific documents, including for the Corporations Act, for Fair Work, for occupational health and safety, for anti-money laundering, all those sorts of things. So grab a copy of that on our website if you're keen. It's $24.95 including postage. So a bargain. Now, those of you who haven't, please join our Facebook group. It's called You Legal for Doctors. It is a free group and people ask questions in there. I add things from time to time to keep you interested. The most recent asset I think I added in there was casual conversion process brochure, which gives you templates to use with your employees if you're converting them from casual employee to part-time employee. So have a look at that. And yeah, I'd love to welcome you into the group, into our community, and to keep in touch. Thank you for all your questions. I'll leave it there if nothing else is coming up, and look forward to keeping in touch.